Can a parole officer conduct a warrantless search of an Airbud case inside of a parolee's pocket? To find out, you have to read People versus Lively, but it's 6 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Lively, published by the New York Court of Appeals on May 21st of 2024. The issue in this case is whether a parole officer can conduct a warrantless search of a parolee's house looking for a parole absconder. To appreciate the context of this case, the background that I think is helpful to know is that there's a case in 1977 from the New York Court of Appeals called People versus Huntley that indicates that this is how it starts. It says, we hold that a parolee's constitutional rights to be secure against unreasonable searches and seizures is not violated when his apartment is searched without a search warrant by his parole officer if the latter's conduct is rationally and reasonably related to the performance of his duty as a parole officer. So everyone has a constitutional right with respect to searches and seizures. A parolee's constitutional rights are somewhat different because a parole officer can search them without a warrant as long as it's reasonably related to their performance as a parole officer. What are the facts in this case? The facts are the defendant is on parole. In February of 2021, Parole receives a tip that a parole absconder may be at the defendant's home. So the parole officer and several others, like 5 or 6 different people, go to the defendant's home to search for the parole absconder at the defendant's house. While they're there looking around, they place the defendant in handcuffs, and the parole officer sees a bulge in the defendant's pocket, checks the pocket, finds that it's an Airbud case, and then opens up the Airbud case and finds heroin. They don't find the parole absconder at the house, and they charge the defendant with criminal possession of a controlled substance in the 3rd degree. The defendant moves to suppress that recovered heroin from the Airbud case as a violation of its constitutional rights. It was a search or seizure without a warrant, and it's unconstitutional according to the defendant. The court conducts a suppression hearing, after which it denies the suppression. At that point, the court finds that the parole officers were acting in the course of their duties. The defendant was convicted of criminal possession of a controlled substance in the 3rd degree. It ultimately goes to the appellate division, and they affirm the conviction in a split decision, and it goes to the Court of Appeals. And here, the Court of Appeals applies that People versus Huntley test we talked about. The defendant does not surrender all of his constitutional rights just by virtue of being a parolee. And in this particular case, they say the question is whether the conduct was rationally and reasonably related to the performance of the parole officer's duties. Here, the parole officers were there searching for a parole absconder, and the parole absconder could not have possibly fit inside of an Airbud case. So the search of that Airbud case was not reasonably related to the function and the reason why they were there to search in the first place. So they say the people failed at the suppression hearing to elicit sufficient evidence about the relationship between the absconder and the defendant, about any violation of the defendant had of his parole conditions, and in particular, they failed to establish that the search of the defendant's pockets, particularly inside of the Airbud, when they realized it's not a weapon, was rationally related to the search for the parole absconder. And for that reason, they shouldn't have conducted the pat-down search, or if they conducted the pat-down search, they should have stopped and not searched inside the case when they realized there was no weapon there. Appellate division of order is reversed, and the conviction is reversed. The indictment is dismissed. And that's the case of People versus Lively. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.